the new date.
Lost
So you lose a year.
a year.
Now, as long as there's no crippling disclosures, it shouldn't be a problem. But it's gotten incrementally harder. I'm not a big fan of it. What I like to do is I call the bare bones utility conversion. Basically, we cleverly prepare a utility conversion with as little work as possible that is based on your provisional application to satisfy the formal requirements for the USPTO. Probably won't be received well when it gets formally examined, but it gives you another year or two to think things over because the patent office isn't going to pick it up for a couple of years, particularly in software. So you got 2 years to think it over. And then once you have it figured out, you can file yet another application that goes all the way back to your provisional. So you preserve that date, and you preserve your rights.
That's cool.
There's all sorts of shenanigans you can do. Well, I shouldn't call it a shenanigan. It's not a shenanigan. It's a creative way around the rules, and allows you to preserve that filing date. And if there's been disclosures, that's why I've had to do it. Is I've had clients come to me with, don't have the funds, I need to keep this pending. What can you do? And this is what I do sometimes.
No, a question. So you said that there is not a whole lot of reviewing has to be done for the provisional.
Mm-hmm.
So then what happens when it's time to go to the utility and then they find that there was some kind of prior art or something before? What happens in that situation? Especially if you had already started using it.
So basically, let me clarify. Your question is, you file a utility conversion. And you're asking about prior art that was available prior to the provisional?
Yes, because you said there wasn't any full kind of research done to do the provisional.
Yeah, it could happen where a prior art exists. That's why we recommend searches first if you can do them. But in that instance, if you can do them, I highly recommend them. And that prevents you from futilely filing. I mean, if you can figure out that it's not patentable before spending many thousands of dollars, that's an optimum situation. And I tell clients, it's better for you to spend money on deployment than on me in a futile effort to get a patent. We can figure out it's not patentable, early on. And that's why we always recommend prior art searches, before filing. Maybe not the provisional, because, why spend $1,000 on a search, if you're going to file a provisional, which even if you hire an attorney is like $2,500 to $3,500. So sometimes it doesn't make sense until you get to the utility. But before you do the utility, you got to do a search. Now, if you're in the situation, the bare bones situation I was talking about, you didn't do a search for the provisional, you didn't do a search for the utility, you haven't spent much money, but you're preserving your rights. Yeah, you might run head smack into prior art, but then again, you didn't spend too much money anyway. So it's not like you spent $10,000 on a software patent application. So it's all sorts of, again, that's kind of the thought process on that. Oh, got my question slide. Ooh. I got my Game of Thrones. I had to bring my Game of Thrones references. So is any additional questions?
So in that case, you're saying that you basically just you're relying on the patent examiner to uncover the prior art.
Yeah, absolutely.
Basically. I mean, and instead of you,
There's no
money to.
Now, when it comes to the search, you have no obligation to search. You do have an obligation to disclose everything to the USPTO that is relevant. So if you got something good, you got to give it to them. So there's a duty to disclose. Like the USPTO operates based upon an expectation that all applicants, their attorneys, their vendors will be honest and operate with candor when it comes to the USPTO. And so they expect you to handle it. So if you know of a disclosure, for example, if you come to me during the filing, after the filing, you say, you know what, I was reviewing our records. We offered to sell this software a year and 2 days before you filed. I have to disclose that to the USPTO. Now, I have to take it to them and say, well, we disclosed it, our own system, which basically means your patent application is going to be dead. So that's why before we file, we do anything, we always ask for complaints, disclosures. And it's not, everyone knows the disclosure of publication. That's easy. Oh yeah, we put it on the website. The problem is offers for sale, and offers to license your software count as disclosures. And the current law out there suggests that even if you're in a deal and you're negotiating with someone to license your software, to sell your software, and you disclose none of the back end of it, you just tell them about the abstract level, the top level, PowerPoint, a pitch deck, that counts as a full and enabling disclosure. Like they can actually get the details out of that, apparently. Again, that was a recent decision, but that's why you got to be very careful when you're discussing licensing and sales of your product. You know, everything should just be informational. We're here, and if you're going to talk to an investor, pitch deck's great, market confidential, NDAs, and just like we're here to just show you the technology. No formal. If you can avoid formal offers for sale or in writing, you know, that would be great. And there could be problems. So
most, in fact, probably all, at least professional venture capital firms, they won't sign an NDA. Because they, or the notion is that they're going to see a lot of similar ideas, and they don't want to be in court saying, you know, I saw this a day before from another company, and so all the litigation that might be involved in terms of where did you first see this idea or whatever. So they just have a blanket policy. We're not going to sign an NDA.
And that's exactly accurate. Same thing with large corporations. Like I want to go talk to, you know, large cap company A. They're good. If they sign anything, it'll be their own non-disclosure that they'll present to you, which will be totally in their favor, of course. So you're kind of in a bad spot. So, but you know, it's in the interest of the VC firm to keep your information confidential. Yeah. I mean, they're not going to if they again, and to disclose to them as little as possible. Like they get top level pitch decks shouldn't be explanations on how the technology works.
Right.
It should be top level, or this is what we want to do. This is what we think we can do. It's just an idea. The secret sauce. Keep for yourself. Oh, we want to see more. Bring your engineers. This came up in Silicon Valley. Yeah, again, don't do that.
Right.
It's true. A lot of this stuff is pretty reasonable stuff. You know, keep it top level. If they want to see the guts, you know, you can show them that's functional. You don't need to show them the guts. That's all they need to see. It works. If they want more than that, then I think
show the money first.
Yeah, either invest or sign an NDA. And I think at that point they would have to make that decision.
I think so.
They would probably, if it works, they're going to want to invest. That's usually what they want to see. All right, it works. We'll invest, and then they don't need to be under an NDA at that point. So let me go ahead and stop the